Good morning. This is the final panel of the conference. After this panel, Professor Dinstein will deliver his fatal blows to all of the speakers who have gone before him. We look forward to that. I have to point out that Professor Schmidt, our beloved department head, gave this panel absolutely no guidance with regard to content. The only guidance he gave me was that I had to put on a tie today, which I haven't worn for about 12 years now. But again, we're blessed because we have three very qualified speakers from diverse backgrounds. First of all, to my right, you may not recognize him. He's the former JAG for Canadian Forces. The gentleman with the long gray hair and the funky bow tie that his wife tied for him this morning. Ken is going to focus on self-defense, terminology, and a wide variety of other topics that he has failed to share with me. He will be followed by Cordula from the ICRC, who will focus primarily on use in bellow. And then Michael, from our neighbor to the north, the Fletcher School, will focus on mechanisms for regulation of cyber warfare. And without further comment, over to you, Professor Watkìn.
Thank you very much, Dennis. So the topic we did get was the road ahead, which seems a little odd since the road is still being paved. But I guess in a way, you all know the definition of a pessimist, right? That's an optimist with experience. And so I'm going to approach this a bit as an optimist with some experience in some tangential, some direct. And two thoughts come to mind. The road is just being paved. The tarmac has not solidified. The technical crew is way ahead of us. The lawyers appear to be sinking somewhat into the pavement, loaded down with something apparently called Lex Lata. And as the cyber world advances to the clouds, someone please tell me that's a marketing tool, and we're not going to have cyber rain in addition to acid rain when the environmental thing hits us. Okay, we have some terminology issues here, right, with respect to cyber. Okay, the second thing is I can claim fully to be a cyber skeptic, and I have some personal experience in this because on December 31st, 1999, I was in the National Headquarters Ops Room for the Joint Task Force that was preparing for Y2K, right? And as midnight approached, nothing happened, despite the best predictions of the technical world from cyber. Now, you guys don't talk about this much, I know that. It's estimated that somewhere around $500 billion was spent preparing for this, and literally nothing happened. But we knew that in Ottawa because nothing had happened in Australia, brought to us by the cyberized media that told us nothing was going to happen. In any event, I was prepared because there's a lot of Canadians in the audience. Ken Lindstein and I had decided to use Ken's old car, which didn't have a computer chip in it by any stretch of the imagination. So we were ready. My favorite moment from the Y2K piece was the Commander Joint Task Force for the North, that's the Arctic for you folks, came down to say, hell, we're not worried about Y2K, it's Y2K here all year round. So anyways, we'll see how it all works out. Look, much has changed since Y2K. Cyber's here to stay. Over 30 countries have on their military order of battle cyber units. The U.S. has a cyber command, cyber fleet, cyber units, right? One of the challenges in all this is whether we have to bring out the old hammer and nail analogy. That because we have military units, we see everything with an armed conflict vision, right? So that's a challenge. However, cyber is a challenge that's shared across government and shared across governments. And there's two challenges that I see in particular. One is the predominant, non-military use of cyber in society, and the other is the fascinating dialogue that's unfolding in international law with what is fundamentally a micro force. I know it when I see it, I can't touch it. It's a ones and zeros we've heard, right? So what is it? That we're trying to regulate. So let's talk about the predominantly non-military use of cyber. You need only look at national policies, and if you look at the 2011 U.S. policy, it says in there, the reach of network technology is pervasive and global for all nations. The underlying infrastructure is or soon will become a national asset. I think national assets are important. So, are we going to defend all that? Is only the military going to defend all that? I mean, what's important? Important enough to go to war over, right? It's one of the key questions. If we look at the UK, US, and Australia policies, however, you have trouble finding defense. It's usually tucked back in the back somewhere, right? Passing reference is made. And those policies focus on a much more pervasive threat, which is cybercrime, fraud, identity theft, economic security. As I say, military is usually at the back of the policy. And so the question is, what really is defense? And what really is the threat in terms of the societies we have to protect? It further heightens the notion of law enforcement as a possible predominant notion than armed conflict as the way to go. My guess is that most of our citizens are more worried about online shopping than about armed cyber attack. And that will ultimately frame the way governments look at this issue from a security perspective. For international lawyers, we will find the security table quite crowded with people we have never met before, with expertise we will find fascinating, and they will talk a completely different legal language. Of course, we compartmentalize everything, so we keep jus ad bellum separate from jus in bello, international human rights separate from domestic human rights, and heaven forbid humanitarian law would butt up against human rights. And with that type of compartmentalization, we will find everyone else around the table to be fascinating. One of the challenges, of course, is domestic law, right? And I've heard domestic law, and it comes at us from the context of authorizations. But the reality is domestic law will be more relevant in terms of restraints, keeping control of this cyber beast and the people who, with the best intentions of the world, are trying to protect their societies. That raises the question is, why is this all in the hands of the domestic human rights folks and the domestic laws that are worried about privacy? And the question is, who is missing in action? I'm still struggling to find a pervasive human rights advocate concern over cyber. Of course, there may be some good reasons because they're not that concerned yet in terms of the threat. So we're embarking down a road. It is a broad road. We're all embarking at different speeds, and there are more of us walking down that road than we're usually used to. The other challenge, of course, is this expansive notion of home fronts. The thought of cyber conflict brings the battles into the boardrooms of the nation, not into the ops rooms of the nations exclusively. It's a much broader concept than the military. What it really calls for is a true application of operational law, all the law that impacts on operations, and not just the law of armed conflict or international humanitarian law as to what we want to call it. For government lawyers, this may be a daunting doctrinal and training challenge as you deal with the new world of cyber. Much has been said about Lex Lata. Of course, it's absolutely essential. After 9/11, I didn't know a military legal officer anywhere in the world, in the governments I was dealing with, that didn't pull AP1 off out of their bookcase to see what the Lex Lata was, even if they weren't parties to Additional Protocol 1 or Additional Protocol 2. But let's be frank, let's be clear. It's a myth that the Lex Lata is all that clear, right? And you need only look to air and missile warfare and naval warfare to really find the treaty laws hard to find. And what you get is very learned documents of collections of views of what the law is or should be. So we're kind of walking on pretty soft pavement still, even with our Lex Lata load. But you know, it is a brave new world, and my favorite cyber story is June 2011 in a little town 30 kilometers north of my hometown, where I'm going to be retiring, where a grandmother, 59 years old, was running a Facebook page on behalf of some folks in Libya and providing the collected information, including possible locations for Gaddafi's headquarters, to it's reported in the paper anyways, to the NATO Twitter site. In order to, it sounds like tactical intelligence to me. I don't know, maybe she was direct participation in hostilities. It does, raise issues of what would the Libyans have done. Presumably the worst thing they could have done was cause her to reload her software. right? And certainly what we had was some interesting geography of war issues. I mean, one of the issues of cyber is, like most of the 9/11 things, it requires us to broaden our horizon in terms of technically induced threats. So let's turn to weapons. Bill, I loved your presentation. I loved the analogy with rifles. The only thing is, when I hand my 20-year-old daughter a rifle, she has a different reaction than when I hand her a laptop. Right? The analogy has a challenge to it all, right? And I think not only will my daughter have a problem with that, I think some of the other, even within government, some of the people we deal with will have trouble accepting that this thing they have every day, and it gets smaller and smaller in their pockets, is actually a weapon. And certainly a weapon of mass destruction. Okay, one of the challenges is it's a microforce, right? And so this raises interesting questions of de minimis. And you think the ICJ case is dealing with less grave uses of force. Think of the de minimis question we've heard that the Talon manual is talking about. Reloading your software is an indication you've been attacked. My God, I've been attacked several times, right? I'm constantly, till I got a new computer, reloading my software. How do you know, right, in terms of all this? What are the consequences of some of these decisions about cyber? So as the hardware gets smaller, we've got to convince someone, I suppose, that the threat is getting bigger, right? Interesting challenge in terms of the dialogue that goes on. But there are other challenges to the dialogue, and one is classification. So like many aspects with respect to contemporary operations, governments keep things classified. They don't even share within governments, right? This can raise questions about who actually talks cyber. Right? Who knows what they're talking about in terms of when you give advice? And what does it mean? It doesn't necessarily mean that you'll either have the right lawyers or the right knowledgeable lawyers around the table, unless the cyber gates, security classification gates, are opened up and you can have a cyber smart dialogue. And of course, where is the human rights community? Because inevitably, you have governments with potentially tremendous power. And who is regulating the governments in terms of protecting ourselves from ourselves? It isn't that there isn't any. I just don't see that it has become as big an issue yet. But it should. And it strikes me that one of the things the human rights community will do the same thing when they started to talk about the targeting issue, is they will go out and hire cyber targeteers on contract to get smarter, right? And so maybe 10 years from now, that's the sort of thing that we'll see going on. But it is one of the players that right now, as I say, is primarily being played by a domestic audience. So let's turn to jus ad bellum. One of the challenges in all this linguistically is we're using the same words, but we're not talking the same language. Okay? Lawyers are late to the road. Right? Someone used the word attack on us. How dare they? Now, if they were really smart, it seems to me that the policy and the doctrinal folks and the operators would say, you can have the word attack back. We didn't know that's what we caused. Right? Because we want to work under the threshold. And if we're using the word attack and that's a problem, you can have it. Of course, we all know that isn't going to happen, right? It's just too deeply embedded. And that's the challenge for lawyers. But we have armed force, use of force, countermeasures. We have thresholds, and we talk about them in a lex lata sense as if they're, written in stone. But the notion of using force as a countermeasure, of course, I need only look to Judge Bruno Sima's dissent, or minority, or whatever it is, in the oil platforms case. I can go to Antonio Casasi's book on international law, and I can pick up Tom Frank's book on the recourse to war, and they all suggest that you can use force as a countermeasure. Very diverse group of very intelligent people. So I wonder if maybe that's the way it will migrate, and we can still keep it within the bounds of where we want to look. There will be changes, and one of the challenges will be for those imbued in the lex lata to face up to some of the myths of lex lata and then actually let go, right? So we have old rules for old conflicts. Any way you want to do it, we have a 70 or a 150-year-old leash on a 21st century beast, right? And I don't know how strong it is in terms of our ability to confront some of the challenges. We are in a more and more complex world, and I was still waiting to hear levy en masse discussed. That's a Lex Lata issue. But, it has relevance. And it has relevance because you get away from even this, where do you want to draw the threshold for non-international, or for organized armed groups? It's never been clear how organized you have to be part of a levy en masse. So, I don't know. There seems to be a lot of scope for a discussion. Okay, so where does that leave us? Of course, there's frontier incidents. And so all I think of is the 2003 power failure in northeastern U.S. and southern Canada. Apparently was caused by ourselves. Our inability to keep modern. Someone said a computer bug if you go online. But, we did it to ourselves. So what is the threshold for grave and less grave? There were some deaths. So is that the threshold we're going to have if someone takes over an electrical system? I always said in Canada, if we had a power failure in the winter, that we would really see how civilized Canada was. So we did in 1998. At minus 30, a large part of eastern Ontario and southern Quebec lost all power. I was very happy to find out my fellow Canadians are very civilized. It required us to call out 2 brigades of the military to assist and get generators out to people, but a tremendous ability to resolve those things. And this raises the issue of what are we going to have as a standard to go to war in terms of even attribution? Because we've also seen that going to war has tremendous financial, reputational, and humanitarian costs in terms of putting the legal discussion in a practical framework. So, we have challenges. We have challenges with comfort zones. And one of the things I look forward to seeing is the first pleading before the ICJ on a cyber attack, to see how well lawyers can change that from the technicality into the legalese. And my guess is we won't be talking about rebooting computer systems, right? It also ranges for lawyers, in terms of when we delve into the policy in other world, is always to remember that maybe we should think about how we might argue all this before a court, as opposed to how we might plead it before the court of public opinion, and leave that to the policy and the public affairs folks, and let them tell the story. So my guess is we can't get off the highway. We're on the information highway. Neither do we want to, because we enjoy its tremendous benefits, and we enjoy them globally. There is a state reluctance to create new IHL. In fact, states love policy, right? Constructive ambiguity, whatever you want to call it. Yoram has quite accurately identified that changes in the law have traditionally come every 25 years until more recently. The last one should have been around 2002. Another way of looking at it is saying states had to have 2 world wars and 70 million dead before states were forced to operate out of a policy environment into a legal environment. Additional Protocol 1 and Additional Protocol 2 were not the creation of states. They were not the creation of institutional groups, whether they be the UN or the ICRC. They were caused by human rights advocates, members of civil society, that forced these institutions, and all institutions are reluctant to change, to come to the table to discuss and create AP1 and AP2. And I guess that's one of the challenges is, where is that change going to come from? Part of the reason it strikes me is that nothing has happened yet. And so, of real big significance, we haven't had this horrendous thing where we say, techies will say, build it and they will come, and the lawyers arrive and they say, oh my gosh, what have they done, right? And so the question is, how do you put framework around our technical advances that we have throughout our life? It seems to me until that dialogue takes place, reciprocity will be the great control. One of the great exchanges that I took away, and very subtle, was the question that was framed to Terry Gill was, would Stuxnet basically, I guess, be an armed attack, which he seemed to say no. And then when Matt Waxman was asked the same question, it was framed in, like, you mean our nuclear systems? Right? There's this reciprocity in terms of how you look at the problem depends where you're sitting. And until that sort of gets sorted out, it seems to me this threshold of grave or less grave will have some fluidity to it. And states, of course, may look at it and say, you know, we'd rather diddle around with a micro force and keep everybody under control than use kinetic force. And maybe we should have a higher threshold here of where we engage the notion of self-defense. So where does that leave us? That leaves us with, we wait till states scare themselves into creating a legal framework. We hope that the human rights community will get more engaged on the international stage, the degree to which they have on the domestic stage in order to keep control. Or perhaps the other way is the dialogue between states. Because it is a wired world, and it is important that regardless of how much power you have in the cyber dynamic, that friends talk to one another and discuss what might be good or bad ideas. Because you never know when you press the button whether the technical guys involved had thought of Y2K. Because one of the challenges is I will always ask a technical person as a result of having lost my New Year's in 1999, 2000, how sure are you about collateral damage? Are you sure the technology is going to work the way you thought it was going to? And it seems to me that's one of the great challenges. Look, this is my last act, I think, as the Stockton chair, and I'd be remiss if I didn't thank everyone at the publicly at the Naval War College. I am Canadian, which means I also lived in a blessed country. Geography blessed, and we're absolutely blessed to have great neighbors, such wonderful neighbors, and that's certainly been shown to me this year. So I'm going home a little earlier than planned, some family issues, but that's fine. And one of the things I'm going to get to do after 35 years of service is do a quintessential Canadian thing, is go canoeing, because we love the outdoors, and I think we're born with paddles in our hand. I hope when I get back from this Y2K experience that the lights are on, but my email never comes out of the cloud. Thank you very much.
Thanks very much, Ken. Cordula, over to you, please.
Thank you, and thanks first to Mike and to the organizers for inviting the ICRC to participate in the conference. So far, it's been a really, really interesting exchange of ideas, I think. I'll concentrate on the use in bello, on IHL. And as Ken was saying, the road ahead is a bit of a difficult question. I'll try to address it first in terms of substance and then a little bit in terms of process. In terms of the substantive law, what's the road ahead? I think over the past 2 days, what we've seen is there's clearly no agreement in the room about the adequacy of IHL in terms of the threats we're facing in cyber warfare. We've heard that we should be very cautious in using the analogies to IHL. We've also heard on the other side that it's normal for IHL to be confronted with new technologies, and that IHL foresees that parties will develop such new technologies, and that it continues to be applicable to new weapons and new technologies. For those who were advocating rather to be cautious, I think I heard three types of arguments. One was an outright argument that was not made so much, but was also made to really have new rules to ban those weapons before we have catastrophic scenarios. There was a lot of suggestion to also look beyond use in bello and to have other bodies of law also apply. And then, you know, the question about a new treaty, new IHL rules, and so forth. But all this also with the background that the discussion was quite broad and didn't always concentrate on, warfare as such, on armed conflict as such, but goes much beyond, goes into cybersecurity. And so, of course, then it's a bit difficult to concentrate on what new rules should be about, because they could also be about security and espionage and so forth, which in any case wouldn't necessarily be regulated by use in bello. Just a quick remark about this outright ban on cyber weapons. I think sort of in the sense of a new arms control treaty, that it was remarked, and I think it's probably the case, that there are enormous practical hurdles to even approach this question in terms of an arms control treaty, just in terms of the enforceability, because of problems of attribution, the verification problems you would have, which exist with other weapons control treaties as well, but of course would be even more problematic with cyber tools and technologies. Also, the difficulty in distinguishing technically between cyber instruments of, say, espionage or other things and cyber instruments of warfare. There was quite a bit of discussion as well about the US or other states' strategic advantage in this, and whether there's even an interest. And so I think the political appetite at the moment, and not only in the US but everywhere else, is certainly not to go down the road of an arms control treaty, despite sometimes remarks by states who do allude to it. But I think what we will rather see is cyber tools being developed and being used in future armed conflicts. And so the question about the adequacy of IHL as an appropriate framework is certainly in the room. Now, from a strict IHL point of view, I think it's true to say, and I think Mike pointed it out, IHL foresees that technologies will be developed, of course, for states parties to Additional Protocol 1. This is made very clear in Article 36 about the review of new weapons. That being said, there has been a lot of discussion in the room about gaps, about hurdles of IHL to cyber warfare. And when you think about the broad structure of IHL, very simply put, of course, in terms of being a balance between military necessity and humanity, we can look at those gaps or hurdles from the point of view, of course, of the broad state interest, which would, I suppose the question of banning weapons altogether would fall into that category. Hurdles in the sense of military necessity. There are discussions, of course, sometimes about whether IHL prevents us to, or certain norms, of course, specific rules of IHL prevent us to fight the wars efficiently. So just to take an example of completely outside of cyber warfare, although it was mentioned, is the rule on perfidy. We've had very serious discussions at the ICRC with certain states who say, we don't like the rule of perfidy, we think we should abolish it because it prevents us first from carrying out certain operations that we think would be useful. So one could ask, which are the rules of IHL which would prevent parties to conflicts to fight their wars efficiently? I haven't heard around the room any of those rules which would put such hurdles to states, but of course that's more for states to analyze, I suppose. The other side of IHL, humanity, is what I want to concentrate about, or more precisely, is what are the gaps, or are there gaps, in terms of the protection of the civilian population, which will not surprise you. And when you look at gaps in a normative framework, of course, you can have very specific gaps. For instance, you have something that is very specifically regulated in one norm, it's not regulated in the other, and a contrario, you can say, okay, there's a gap, and this is not regulated. I think, broadly speaking, for the rules that are the most relevant for cyberspace, which are the rules on the conduct of hostilities, those rules are generally very broadly phrased, and so you will hardly find really a very explicit gap in those rules, which would lead to a lack of protection, legal protection of the civilian population. That being said, I think there are two other not exactly normative, but two other gaps in legal protections that you could have. One would stem from an interpretation of rules, and the other is if existing rules, which are already weak, and many of the rules on the conduct of hostilities are weak when it comes to the protection of the civilian population, are exacerbated in their humanitarian consequences for these new situations, and in this particular case for the situation of cyber warfare. Because, of course, the fact that the rules are so open on the conduct of hostilities, and which allows us to say they can be adapted to new technologies, is their strength. But it can also be a weakness, of course, if they're interpreted in a way that doesn't provide this legal protection. So I'll give you maybe an example or two of what I mean by an interpretative gap. And one of them we talked about for quite a bit, and that could be if we have interpretations of the definitions of armed conflicts, the threshold of armed conflicts, which would basically mean that the jus in bello doesn't apply anymore. What do I mean is we've heard quite a bit about, well, maybe the jus in bello isn't the path to go down. Now, normally, whether IHL applies or not isn't a choice. You know, legally, conceptually, legally speaking, it's whether you have an armed conflict or not. And that doesn't depend on whether the state decides that it's an armed conflict or not, but actually on how it carries out its operations. And so if we take an interpretation which would allow us to say, well, we now, for instance, in international armed conflict, define the threshold in a different way than it was done by the traditional Pictet theory, which means any use of force between two states. I should actually call it the new Schmidt theory, because I think it was rephrased yesterday from the Pictet theory to the Schmidt theory. Then you could say, and I think that that's particularly true in cyber warfare, or there's a particular risk in cyber warfare, that maybe we are biased now by Stuxnet because it's the one example we can see, but states could say, well, we just have an isolated incident. We didn't mean to have an armed conflict, and therefore we shouldn't call this an armed conflict. And we have this already with isolated incidents, of course, in the kinetic world, that even though in theory isolated incidents of use of force trigger an armed conflict, very often they haven't been treated as such because they're over and, you know, you don't need to talk about an armed conflict. But of course, if that leads to a circumvention of the protections that IHL provides, then that would be of concern. The second, and I think the crucial question, of course, is the question within jus in bello about armed attacks and what constitutes an armed attack. And there again, I think the interpretation that we will give to armed attacks at the end of the day will show whether there's a legal gap for the protection of the civilian population or not. There was a bit of a discussion between Professor von Heineck and Noam Lubel yesterday about what are the consequences of calling something an armed attack. Is it better? Is it less protective? Is it more protective? It depends from what perspective you see it, but if you accept that not all military operations or hostilities trigger the application of the principles of distinction, proportionality, and precaution, but armed attacks, then it's crucial, of course, to decide whether something is an armed attack or not. Now, there was, and maybe it's being overcome, a big debate on whether we are only talking about beyond injury to person when we talk about infrastructure, whether it's only physical damage to infrastructure which would be one, say, extreme position, and the other extreme position would be to say, well, any website that's being disabled. And in between that, you have to decide, well, what is it actually that's an armed attack? I think to say only physical damage to things would certainly be a very restrictive interpretation, which would leave a lot of civilian infrastructure vulnerable to direct attacks. To say, of course, any website that's being subject to denial of service attack or communications means or Facebook or whatever being attacked or disabled as an armed attack would probably go too far. And I think we have to look at the object and purpose of what the law on the conduct of hostilities wants to do. And my sense is to say, well, the law on the conduct of hostilities, it doesn't protect civilians from being left alone, but it wants to protect civilians from being harmed, in the sense that you're not going to be safe from propaganda or other operations but you should be safe from your electricity networks or water networks, etc., being harmed or disabled. But again, we don't know how states will interpret these concepts, and I think that will be critical for the protection of the civilian population. The other potential normative gap, and again, I'm quite aware that normative gap is probably not the conceptually correct term I'm using, but it's to illustrate a gap in protection, really, would be if the weaknesses of the existing rules or of the interpretations we've given to such existing rules are exacerbated by cyber warfare. And I think there is a risk that might be the case in several respects. Just two that I want to stress. The one was already stressed a bit earlier this morning by Robin Geis, which is the fact that, of course, we already have a lot of civilian infrastructure in the real world, in the physical world, which is dual use. Power grids, power supplies, sometimes chemical industry, communication systems, transport systems, etc. And so, of course, that means they're vulnerable, but they're also civilian infrastructure. And I think there are two risks of how that could be exacerbated in terms of cyber warfare. One is, I think, some of these infrastructures are more reachable. I think Eric Jensen used this word once, or this expression once in one of his articles. They're more reachable, more vulnerable, maybe, to remote cyber attacks than they might have been for kinetic attacks. And in that sense, you know, there's a higher risk for the civilian infrastructure as well. The other one is, of course, that, as Robin pointed out, and I think I agree with him, virtually, if not all of the entire cyberspace is dual use. And that means the entire cyberspace, which also underlies those civilian systems which as such might not be dual use, but which rely on a system which is dual use and therefore a targetable military objective. Now, that is the lex lata in a way. Dual use things are military objectives, they are targetable. And if we live in a world where most things are dual use, that I think creates a serious problem for the civilian population. I think what it means in practice is that the principle of distinction will actually not be very relevant or help. I should not take too strong words, but it will not be the most protective principle in this respect. What we will see probably, I suppose, is that we will very quickly go to the principle of proportionality. Because, of course, then we can always say, well, those bits of the civilian infrastructure, etc., which are not military objectives must be protected against incidental damage. But the principle of proportionality is, of course, notoriously vague and relatively weak. And when you look over the years, you can see that although the principle of proportionality has, I think, really over the century contributed to the protection of the civilian population in terms of the amounts of death and injury and so forth that we tolerate, but when it comes to objects, to civilian objects, civilian infrastructure, I think the awareness and for the consequences on civilian infrastructure and the tolerance for damage to civilian infrastructure is such that there is a real concern, I think, in future warfare for what it could cause to civilian infrastructure. The other example is probably the definition of military objectives. Now, for most of us, military objectives are such objects that make an effective contribution to military action. But of course, for some, they include war-sustaining activity, objects which are war-sustaining, which could include, for instance, financial systems. Now, again, here you have an interpretation on which people disagree, of course, but if you take the war-sustaining approach and you take financial system, and it's very clear that financial systems are kind of the perfect example of what is vulnerable to cyber warfare, I think then we have we probably have a normative gap for the protection of the civilian population. So again, I think we will, to close on the substance, I think in terms of the general rules, it's difficult to say we have clear gaps. And I think whether we have gaps in legal protection will, in fact, at the end of the day, depend on state practice and on states' legal positions. And as Ken pointed out earlier, we have problems of classification to find this out. States love policy and they love constructive ambiguity. And so we're not clear yet about where those fault lines, where those gaps might lie. It's true maybe that since international armed conflict might be the more applicable situation of cyber warfare, reciprocity might be one thing that might be contributing to protection. But as Robin was also pointing out, although it is the main scenario, it might not be the only scenario, and so we will have asymmetric conflicts, non-international armed conflicts also, and in those, reciprocity, as we know, is a bit weaker as a protective system. Now, in terms of process, where does this leave us? Because it means that at this stage, at least as far as I see, I think we are still not completely clear about whether we need a strengthening, as it were, of IHL. And I think what we see is that the Tallinn Manual discussion to date is the most serious and most advanced reflection about the applicability of the rules, what they mean exactly, and so forth. But it is done at an expert level. When you look at interstate processes, you have quite a few processes, quite a few initiatives. So, for instance, you have the UN process in the group of governmental experts, which started in 2003. Alexandra Perina alluded to it in her remarks as well. The group submitted a report in 2010. One of its recommendations was very, very vague, which says, well, non-criminal areas, so I suppose that means security, maybe warfare, of transnational concern should receive appropriate attention. These include the risk of misperception resulting from a lack of shared understanding regarding international norms pertaining to state use of ICTs, which could affect crisis management in the event of major incidents. So we wonder what major incidents could be. And we know that the United States submitted actually a legal position to that group, but in terms of warfare and in terms of IHL, there is no discussion as yet. We have a process in the OSCE. One of its goals is to potentially develop norms relevant to the behavior of states in cyberspace, which is much, much broader, of course, than IHL or cyber warfare. We had the London conference last year in November, which will be followed by a conference in Budapest and one in Seoul, much broader than warfare. It's about cybersecurity, and warfare is actually basically something that I think, or my impression is, participants don't really want to touch it. You have the Shanghai Cooperation Organization, which has an agreement and which talks about information warfare, information war. It talks about information weapons and information terrorism. But the concepts are much, much broader than what we would call weapons and what we would call armed conflicts. And so, in that sense as well, we're not exactly clear what does that mean. And of course, when then, for instance, Russia or China say, well, IHL doesn't necessarily apply to information war, that's actually quite logical, because not all of what they call information war is what is an armed conflict. So the focus, I think, at the interstate level, at least that's my impression, is on cybersecurity, not on cyber warfare. Cyber warfare gets lost in the debate. So there's a divergence of view of what warfare would even be, let alone armed conflict, and therefore, of course, as well about the IHL framework that could be applicable. In all of these processes, states remain very vague about their legal positions, the emphasis is really on confidence-building measures, not on law and on legal questions. So where does that leave us? The rest of us are left to speculate, I think, about states' legal positions and also about state future practice. And so all we can do, I think, at this stage is to point to the consequences of the legal choices that states will make, both legal consequences as well as the humanitarian consequences. Thank you.
Thank you very much. Michael?
Thank you very much, Dennis. Michael, thank you for inviting me to be here and for organizing this. I, too, want to say a few words about gaps. And I want to address specifically two questions. First question is, are there gaps in the law that we've been discussing over the last 3 days? And second, what is the likelihood that the international law, international rules regulating these matters will be tightened up? So the first question, I must say, thinking about a number of the presentations that one has heard, one could easily come to the conclusion or get the impression that there are no gaps. One might conclude that the prevailing image is that it's only a matter of finding the right category or classification, that there are no gaps because these categories are all-encompassing and comprehensive, and that the process of answering a question that arises is one of going through a decision tree, and in this fairly elaborate scheme, going from one category to the next and coming to the correct conclusion, so that we've seen lots and lots of these categories over the last several days. Force, no force. Attack, not attack. Armed, not armed. Combatant, not combatant. In each case, you confront essentially a binary choice about whether to classify the act or thing in question based upon this pre-existing category. And the suggestion almost seems to be that if you think long enough and hard enough about it and do all the legal research that you need to do, you will identify the correct answer. And if you don't know what the correct answer is, keep thinking, Go home, close your eyes, sit down in your easy chair, get the ratio of gin to vermouth exactly right, and reread the underlined passages in the Critique of Pure Reason, put on some Bach, relax, and the correct classification will come to you, and you will arrive at the proper answer, that there is one correct answer if you follow the scheme of classification and the decision tree correctly. The notion is that in effect you too can be Judge Hercules. You can with every other right-thinking person identify the one true answer. Now, this approach to law has been described in a number of ways over the years. VJ yesterday referred to it as a category-based approach, many other legal scholars over the course of 100 years have been somewhat less charitable, describing it as arid formalism or legal fundamentalism. I'm going to avoid the pejoratives, but say two things about this approach to law. One, about this approach to law generally, and second, about this approach to law in the international legal order. First, generally, categories are not all there is to law. Someone who does law well, a good lawyer, doesn't look only at classification. It's not, good lawyering is not simply a process of, identifying the salient characteristics of an act or a thing and placing it in the right category and then moving on to the next category and doing that over and over and over until you come to the right answer. What else would a good lawyer look at? Well, at the purpose behind the category, about whether the category is still relevant to changed times and circumstances, about the consequences as a policy matter of interpreting that category in a certain way and classifying the thing or act in the way that is argued for. A good lawyer would look at the structure of incentives and disincentives that will be created by interpreting the rule one way versus the other. So it's a much more complex process, frankly, than simply engaging in categorization. And if you don't take into account as a lawyer all of those exogenous factors that I just described and many other ones like them, you're really doing your client and the law a disservice because it produces a kind of illusory certainty. It suggests that the categories actually produce the results, that the outcomes are the consequences of forms, hence the term formalism, but they're not really, because there's more going on that dictate the consequences, and they're not reflected in the categories. That's the downside of formalism. That's why it's gotten the bad name that it has. If, on the other hand, you take those things into account, you can give life to the law. You can give contemporary relevance to the law. You can make the law a living instrument capable of adapting to changed times and circumstances, something that has play at the joints. So that's a general comment about formalism. Second, this approach, the light switch on-off approach that we saw in our little vote the other day, is Stuxnet a use of force? Is Stuxnet not a use of force? This light switch mode of analysis in the international legal order is simply flat wrong. I'll repeat that. It is simply flat wrong. And it's wrong for a reason that international lawyers know. There's a third choice. And the third choice is the law does not provide an answer. There is no answer. Reasonable people can disagree as to whether the categories apply. Now, as lawyers, we recoil at the notion of a lawless zone. Somebody on the last panel just referred to the horror of a vacuum in the law. We're trained to run away from that. I mean, it's beyond this point there be dragons. You're looking into a legal abyss, we think. when we conclude that the law provides no answer. In international law, that is not true. And the reason that it's not true is international law has a default answer to the question. What is the law? What is the restraint? When the law is not clear, when there is a gap in the law, when the answer is that there is no answer. And the default answer is something called the freedom principle. The default answer is that a state is deemed to be free to act unless another state that argues that there's some restriction on that state's freedom meets the burden of persuasion in establishing that that restriction exists. And absent the states meeting that burden of persuasion, the state is deemed free to act. That's the answer that international law gives. And over and over and over in our analysis, I suggest to you over the last 3 days, the freedom principle looms large because these are questions over and over and over, as you've seen, on which reasonable people can differ. And the accurate answer, the honest answer, the answer that leads to a legal system of integrity and clarity and predictability, not false certainty, but true clarity and true certainty. The answer is that there is no answer, that states are free to act. So that's the introductory comment on formalism and whether there are gaps. Now, so I don't phrase the second question as a question of whether the gaps can be filled. The question is it likely that the law is moving in a direction in which greater restraints will be placed on the freedom of states, or to put it more in consonant with the Lotus case, where, of course, the freedom principle originates, are states likely to consent to greater restrictions on their freedom of action? And my suggestion in this regard is that, and I see I talked longer about the first point than I had intended to, and won't have time to go through the whole analysis of the second point, but I'm going to try to curtail it. That there's the short answer is that there's some reason to hope, if you believe that legal restraints are appropriately tightened up, there's some reason to hope that the law is moving in that direction. But as Matt Waxman suggested the other day, the real question is what you want the law to do. What function do you want the law to perform? What's the objective in hoping for greater legal tightness or greater regulation? Law is a form of cooperation. Cooperation in itself is neither good nor bad. I mean, the Third Reich exhibited a high degree of cooperation in operating the death camps. Law is, in that sense, a means to an end. And the question in every case is, do we really, based on lots of different factors, feel that it would be appropriate to have further regulation? So my suggestion is that you really have to take a greater legalism is not in and of itself something to be desired. It depends upon the substance and the effects and the consequences of the rules that might emerge. And the likelihood that rules will emerge is a function and will be a function of prevailing conditions. What are those what are those conditions? And why do I think that it's unlikely that these rules will emerge? First, the most important is probably the shadow of the future, the expectation of future dealings with the other party. If you don't know who the sponsor of a cyber attack is, because the operation is clandestine or covert, then the future has no shadow, and no one need be concerned about future rewards or penalties. Retaliation is impossible. The law can impose no penalties. If the operation is overt, on the other hand, and future dealings are likely, then the incentive is greater to come up with a mutually advantageous rule, like the rule in the UN Charter prohibiting use of force. The second background condition is the ability to identify and penalize defectors. But again, given the attribution problem in this realm of the law, that's extremely difficult to do. It is highly improbable that an international agreement can be drafted that will regulate the writing or storage of computer code that is useful for launching a clandestine cyber attack for obvious reasons. A third condition is that actors within the system have relatively equal capabilities, but because of the secrecy that surrounds this issue, it's very difficult for states to make that assessment before the fact, and it's improbable, therefore, that they will enter into treaties. Well, we can get into these conditions in greater depth afterwards. I'll just conclude with the suggestion that there are various scenarios that emerge depending upon which conditions prevail. There is in the future a good possibility of a continuation and acceleration of the process that we've seen of attack and response, and I use those words not as terms of art. And I would call this a kind of drip war or perpetual cyber war, and the likelihood of this happening is one that's very difficult to assess because of the secrecy surrounding it, as I say, but I would not underestimate the institutional costs that lurk in that scenario of drip attacks and reprisals. In a cascade of unending cyber attacks and counterattacks, the risk assessment of warfighting would be carried on behind closed doors in the security of skiffs, safely immune from legislative or public scrutiny. Cyber attacks would be seen as sources and methods which would be kept secret from the Congress. No citizenry would be aroused to object. Indeed, the public wouldn't even know that the attack had been launched. Which states or terrorists are behind the attack would be anyone's guess. Retaliatory attacks, as well as preventive and preemptive attacks, would have to be launched instantaneously based upon an adversary's presumed intent in capability and inferred motives rather than actual or apparent provocations. As a result, drip strikes and something very much like war would occur more often in more places against more targets based on ever weaker evidence and with ever graver results. If that's the road that we're on, it seems to me that we could be in for a rough ride.